and gentlemen. Our first case this morning is 2020-823, the State of Ohio, ex-rel J. John Stone versus the City of Cincinnati. For this city, we have Mr. Hicks.
Madam Chief Justice, and may it please the court, William Hicks for respondent, appellant, City of Cincinnati. I would like at this point to reserve 3 minutes for rebuttal. At first blush, this case appears to be a simple matter of a writ of mandamus related to the promotion of a single captain in the City of Cincinnati's police force, who, as at this point, has already been promoted to captain. However, if the district court's opinion is affirmed, it will in essence render the 2007 amendments to Revised Code 124.44 inoperative and superfluous and violate various other rules of statutory interpretation. And additionally, it will conflict with the provisions and the principles surrounding writs of mandamus and the traditional broad discretion that is accorded to municipal civil service commissions, particularly in the area of competitive promotional examinations. As such, we believe the decision of the district court should be reversed. Initially, the rules of statutory interpretation that apply to this are multiple. First, as the court is well aware, the plain language of the statute is used to determine the legislative intent. The language in this amendment in 2007 was, municipal civil service commissions may require a period of service longer than 12 months for a promotion to the rank, singular, immediately above the rank of patrol officer, which, as conceded by respondent or by appellant, is sergeant. You have to presume under the rules of statutory interpretation that the legislature chose the words that they selected for a reason. Had they wanted this amendment to apply to other ranks, they could have said ranks and stopped there. Instead, they said rank, singular, immediately above the rank of patrol officer. And additionally, the rules of statutory interpretation provide that any interpretation that renders a statutory provision meaningless and is disfavored and to be avoided. And the district court's opinion renders the last paragraph superfluous and inoperative. Additionally, another important rule of statutory interpretation that applies in this case is the expression of one thing implies the exclusion of another. Here, the expression that the rank singular immediately above the role of patrol officer implies that other ranks above that are not provided for and cannot have a time and grade requirement longer than 12 months. Further, the legislative history supports the city's position in this case. The legislative history, while very sparse, essentially restates the sentence that was added to Revised Code 124.44 and says this was added to allow municipal courts, municipal civil service commissions to require a period of service longer than 12 months for the rank immediately above the rank of patrol officer. Now, there was substantial discussion in the trial court and the district court regarding an advisory, what I would term an advisory opinion of the Civil Service Commission that was issued approximately 2 months after their initial ruling that was based on the city solicitor's opinion to allow police lieutenants with greater than 1 year and less than 2 years to sit for the examination. That advisory opinion was issued and discussed that it was not precedent setting and discussed this was based on the principles of equity, diversity, and equal opportunity.
Did you, excuse me, Mr. Hicks, but I couldn't really tell that the Civil Service Commission actually in the first instance when it allowed those 3 officers to take the test the next day, that it actually relied on the solicitor's opinion. It looked like it just was a factor mentioned along with a lot of other arguments. Is that an issue?
But I wasn't getting it all, but when they're in their minutes, they cite to the opinion from the solicitor's office And they that position was also given orally during the Civil Service Commission meeting, because I was the one who actually gave it. But I don't think that is dispositive in this case. I think the fact that they later changed the class specifications for both lieutenant and captain and attached that opinion that was under the name of the city manager, but it was written by the solicitor's office for him to disseminate, illustrates that advisory opinion was not only, it was never followed and was subsequently discarded. And from our perspective, that is irrelevant. There's the principle that courts will not reverse correct judgments if based on erroneous rationales. Here, there's even a step farther from that, because the erroneous rationale, to the degree that the equity and diversity and equal opportunity argument in that advisory opinion, it was never followed. And so we're even a step beyond that. So even if the commission had given some bizarre erroneous rationale and had actually followed that, as long as that there was support for the correct rationale, then there was a correct decision, ultimately, that should be affirmed. Additionally, courts should exercise great caution when issuing writs of mandamus. And the cases, litany of cases discuss the fact that you should have clear and convincing evidence, and courts should not substitute their judgment for the commission. And reiterating that in the areas of competitive promotional examinations, the civil service commissions have broad discretion. Unfortunately, based on the trial court and the Court of Appeals decisions, they essentially ignored these mandates and essentially substituted their judgment for the commission. And the Court of Appeals, in its decision, noted that they were reviewing it de novo, but they give deference to the decisions of civil service commissions, and they will generally not intervene absent an abuse of discretion. And in this case, the Civil Service Commission was relying upon a reasonable, well thought out opinion from the city solicitor that, based on multiple rules of statutory interpretation, we believe is 100% correct. But even to the degree that there is question over whether that is 100% correct, that deference to civil service commissions, as well as the overriding caution that is to be exercised in writs of mandamus, should prevail and supports the Civil Service Commission's decision to waive the 2-year time and grade requirement in this case.
Mr. Hicks, ultimately in 2017, when the Civil Service Commission reached its policy, it cited diversity and equal opportunity. So was that a forward-thinking policy?
To be honest, Your Honor, I do not. I know the individual in the HR department actually wrote that, and I do not know what they were thinking. And in all honesty, I don't believe that would be a valid rationale under the U.S. Supreme Court's Ricci versus DiStefano or other cases to use an actual protected class such as equity and diversity, which seems to be implied there. I don't think that would be a valid way to excuse the 2-year time and grade. I know several of the candidates who appeared before the commission, when they were there, made comments about equity and diversity being reasons for their request, and possibly that colored the HR department / Civil Service Commission's decision to issue that.
I think diversity and equal opportunity. Equity was another one.
Yes, and I think those all sort of, I sort of read them together, but I believe that those would not be valid. And I don't know what their true intent was there.
Is it okay?
I'm sorry, I didn't like.
Are you arguing that it shouldn't be in there?
Yeah, I think at least there should be great caution exercised when citing diversity or other potentially protected classes in changing a rule.
It didn't really cite any federal statute, any federal law or regulation. It just spoke about diversity and equal opportunity. Are we bound by that kind of a consideration?
Obviously, we have to be equitable in the exercise of our civil service rules, but I do not know exactly what they were saying in there. And given that it was never followed, I mean, it's really sort of, I think, sort of almost an illusory, this advisory opinion is essentially meaningless. It'd be one thing if they had taken some people out of the process or made any actions upon it, but there was no action ever taken in reliance with regard to that February 2017, what I would term advisory opinion. And they have their subsequent actions.
Does it really matter? This is a mandamus action, right? So in order to demonstrate entitlement to relief, the petitioner has to show that he has a clear legal right to be able to take the exam. Does it matter what logic the civil service gave if the statute says that he is not entitled to take it? I mean, how can he show a clear legal right?
I don't believe he can. And actually, and he had the clear legal right because he had over 2 years. Where he really has his problem is with Captain Swingley, who finished number 1 on the exam, and he was the individual who had less than 2 years.
Right.
And more than
I misspoke. So he has to show a clear legal right that the other officer couldn't take the exam. And if the statute says he can't, how can he demonstrate that?
Yeah, I do not believe he can, Your Honor. And quite honestly, I believe that this would be more appropriate for a writ of quo warranto, but he specifically sort of wants to have his cake and eat it too. He wants to be able to pass the exam, be able to be promoted, yet he doesn't want to force his fellow officer who finished number 1 to not be in that position. And so, we believe that there's no real position open because, all he was asking for is to be placed in a position he had a clear legal duty and a clear right to, but there are 2 people in those positions and were promoted. And I believe I'm at the end of my 3 minutes left.
All right. Thank you very much. Mr. Rule.
Good morning, Chief Justice O'Connor, and may it please the court. George Rule on behalf of Relator Appellee Jay Johnstone. The appellee's position in this case is really straightforward. The Cincinnati Civil Service Commission decision was an abuse of discretion.
Why does that matter? I mean, again, your client has to demonstrate a clear legal right. If the statute doesn't provide an entitlement to relief, how can he demonstrate a clear legal right? I mean, even if the Civil Service Commission did the right thing for the wrong reason, that doesn't give your client a clear legal right to the position.
Your Honor, with respect to this particular case, the Civil Service Commission expressly stated that it was...
Okay, but why does it matter what they expressly stated if your client did not have an entitlement to the position? I mean, even if the Civil Service Commission got its reasons wrong, but came to the right result, how does that give your client an entitlement to the position? How can your client show a clear legal right here?
He finished 3rd on the exam, which was made him next up for promotion. But I would also submit, Your Honor, that the statute doesn't say what the city says it says. And if you look at the language of the statute, and you look at the plain language of the statute, the legislature very easily could have stated what the city wants the statute to say. It could have used prescriptive language, which it did not. And if you actually look at the legislative intent...
Well, but by that argument, why did the legislature add the last sentence? Municipal civil service may require a period of service of longer than 12 months for promotion to the rank immediately above the rank of patrol officer. I mean, under your reading of the statute, that sentence is completely unnecessary.
That sentence provides and makes it clear that the Civil Service Commission has flexibility to require a longer period of time. The
Or the
language.
rank immediately above the rank of patrol officer, it makes it clear. But you say it doesn't need, you don't need that sentence at all under your reading, right?
No, I don't think it renders the language superfluous. It simply supports the legislative.
But you say that you say that the first three sentences or four sentences already say that the city can require more than 12 months for any position, right?
Correct.
Isn't that your reading? So why did the legislature bother adding that last sentence?
Well, Your Honor, in terms of looking at the recommendations of the Civil Service Review Commission, which the General Assembly created that commission, and that language, and that's cited at page 64 of our appendix, indicates that a municipal civil service commission should have the flexibility to set minimum service requirements for promotional examinations. The judgment of how much time is adequate to prepare for command level appointments should be made at the local level.
Again, so why did they add that last sentence?
I can't answer that question.
Mr. Rule, 124.44, the first sentence deals with original appointment above the rank of patrol officer. Basically, no positions above the rank of patrol officer in the police department shall be filled by original appointment. So that doesn't really speak to anything beyond patrol, correct?
Correct.
I mean, except that you can't fill it by original appointment. So then the process is sort of a two requirement on this statute. One being the taking a test, the other having served at least a year. And then somehow then, I think maybe it was in 2007, this last sentence was added. But I guess I can't see anything in this section that prohibits the Civil Service Commission from putting that 2-year requirement, for instance, to go from lieutenant to captain. Do you read it that way?
I agree with that, Your Honor. And as we argued in our brief, the language of that last sentence is permissive in terms of may require. And in fact, the final decision, February 2nd, of the Civil Service Commission indicates that there's nothing in 124.44 that prohibits a Civil Service Commission from allowing somebody to make an exception to allow someone to sit for an exam.
So then the default then is the Civil Service Commission rule, which is you got to be there for 2 years. So I guess my question to you, even though your client is a captain now, if you prove that he was entitled to have that observed, meaning that he had a right as far as mandamus goes, a clear legal right, does he have then the option to seek back pay for having been passed over by two people who had not been serving for a year, but they scored higher on the test, or for 2 years, but they scored higher on the test? Does he have a right to seek back pay for that?
Yes, Your Honor, because as the trial court found and the first district affirmed, he established a clear legal right to the promotion and should have been promoted as of April 2017. And so for that period of time, before he actually got promoted in 2019, he should have been a captain.
So
counsel, there was a 2-year requirement, right, in order to take the test initially.
Correct.
And then the Civil Service Commission knocked that down to 1 year. And that opened the field to more takers of the test. Correct?
Yes.
And you're saying they had no right or authority to change from the 2-year to the 1 year. Is that correct?
No, they absolutely had discretion to set the requirements. They just couldn't do it in an arbitrary manner, which is
what would have satisfied you as a reason for them to have done this. The reasons they gave, I guess it was 2 months later, certainly I think are valid. But again, what demonstrates an abuse of the process by the commission?
Well, there has to be a foundational basis for the decision.
Like what? Give me an example.
The statute. I mean, if the Civil Service Commission had said in their decision, we're relying on the statute, or we're relying on the arguments of the petitioners.
All right. So what the statute, we're relying on the statute because the statute says it's only 12 months, other than the jump from patrol to sergeant. They had to spell that out.
Well, that would have given the relator, that would have given the trial court, this court, some foundational basis for concluding that this decision wasn't arbitrary. And, I think
the decision, wait a second, if the decision comports with the statute, which it does, they can do 12 months. They could do 15 months. They could do, as long as it's above 12 months. And they downgraded 24 to 12 months. They were entitled to do that. You're saying, and statutorily, they were entitled to do that. And you're saying because they didn't say the magic words, we're doing this according to 124, whatever, that it's an abuse of discretion.
It's an abuse of discretion because how they rendered the decision. What the trial court found, and this is from the judge's opinion, the decision to do a one-time waiver of an entrenched 2-year time and grade policy, which a ruling by the same commission previously upheld under the principles of equity, diversity, and equal opportunity, without establishing any precedent or practice for future police promotional examinations, is, in this court's opinion, obviously arbitrary.
Counselor, what it seems like, so that you're challenging the test, the waiver of the 2-year requirement, which maybe could have been stopped in prohibition, but had this test gone on just like it did, and your client score first or second, is it your assertion that he then would have been promoted to captain because he would have been number 1 or 2 on the test, on the exam? But it seems to me if everything happened this way and he finished 1 or 2, yet someone who finished 3rd or 4th was promoted instead, that seems to be this argument. But you're challenging the test. Shouldn't there have been some legal action filed to prohibit the administration of the test with eligibility for people who had not been in the service rank for 2 years?
Well, part of the problem with this decision and why it's an abuse of discretion is because they allowed the test takers to take the test the day before the exam. I mean, there was absolutely no time for Captain Johnstone or anyone else to try to stop that. I mean, they made the decision the day before the exam.
So they made the decision. I thought you said they allowed them to take it the day before the exam, and I thought, no, you said they made the decision the day before.
I misspoke. They issued a the committee notes reflect that they were allowed them to take the exam and that they were going to make a final decision at a later point.
Final decision regarding what?
A final decision whether it was appropriate to allow anyone with less than 2 years time and grade to take the exam.
Okay.
All right, so they allowed the those with a minimum 1 year to take the exam. And they didn't make any representation even afterwards when they issued, their statements 2 months later about the permanency of this this requirement, the downgrade from 2 years to 1. Do you find if they would have said, and this is how this will be the, the rule going forward, would that change where you are on this?
No, Your Honor, unless they had given a foundational, they're not allowed to make an arbitrary decision. I mean, there has to be some foundational, adequate determining principle.
Well, it comports with the requirements of the statute, and then they gave the equality, diversity, and equal opportunity as a basis for doing that. Which, would you disagree that that's legitimate? That's a legitimate basis for the commission to do its work this way?
I'm not against equal opportunity or equity or diversity. However, there has to be a foundational basis in the record to base their decision on those principles, which were.
Okay, do you find, without establishing any precedent or practice for future police promotional examinations, is that what's troubling you?
That is troubling, but it's the entire decision in and of itself. There's a long-standing precedent of 2 years time and grade in the city of Cincinnati, which the legislative record and the statute and the history have always dictated that local civil service commissions have flexibility to set the requirements. The police department argued in favor of keeping that 2 year time and grade requirement. And then for the Civil Service Commission to throw that out and say, this is on a one-time basis. I do have a problem with that. We're not going to rely on it in the.
What happens to the two current captains who took the exam and were promoted with less than 1 year, less than 2 year?
Well, one of the captains had 2 years. There was only one captain at issue, but
okay.
As we argued in the lower court there, which was not what the case was decided on, there was an opening at the time of expiration. Captain Bailey had retired, and it's also the first district followed its own case law in the York versus City of Cincinnati case, because as the next highest scoring test taker, that then Lieutenant Johnstone had a vested right in that promotion.
Okay, my question is, what happens to the test taker who had less than 2 years but was promoted?
Nothing.
That's then, in other words, he's holding that position legitimately right now.
Well, Your Honor, he was 4 months. He was 4 months shy.
Doesn't matter. Doesn't matter. You're arguing it had to be the 2 year in compliance. So you're saying that he's wrongfully in that position.
That wasn't Captain Johnstone's position during this case.
Well, I'm trying to figure out, what's the long-term effect if you prevail. There's got to be consequences, not only in this situation, but others similarly situated. What are they?
Well, as established in the record, Captain Johnstone has been promoted because there was a vacancy. So it's really, it's a matter of lost pay. And there was a vacancy at the time the case was filed is our position. So in terms of looking at the particular facts of this case, there's no impact, negative impact on Captain Swingley. And in our view, there is no impact on the statute, because the particular facts of this case, the Civil Service Commission did not base its decision on the statute. It's in the plain language of their decision.
Mr. Rule, this didn't come out of nowhere. There were 4 lieutenants who actually challenged the Civil Service Commission's rule, and so they addressed it. And are you telling me that the Civil Service Commission didn't have the ability under the general statute empowering its existence and operation to do that, even for a one-time?
No, Your Honor. The Civil Service Commission did have discretion to set the time and grade requirement. What the trial court found and what the first district affirmed is they can't exercise that discretion arbitrarily, which is exactly what they did in this case. So they did have discretion, but they can't just pull out of left field some basis that has no foundation in the record. We're going to make the decision based on equity. Okay, I mean, they have to have a foundational basis that is rational and not arbitrary and not capricious to make the decision. And Relator Johnstone established that in the trial court, that it was an abuse of discretion, and that he had a clear legal right to the promotion.
Thank you.
Thank you.
Thank you.
Mr. Rule.
That's all I have. Thank you.
Mr. Hicks.
Madam Chief Justice, Court, just to respond, I think that it's clear here that the Civil Service Commission, the problem with the Court of Appeals decision is they have great discretion, Civil Service Commission, in this area. And the appellee continues to describe this, advisory opinion as pulling out of left field and there's nothing in the record. I think it's important to note that this is a writ of mandamus. This was not an administrative appeal where there's a record set in the Civil Service Commission upon which under 2506, you rely, and that is what guides the case through. This was a writ of mandamus, which, as the court is well aware, is an extraordinary writ that the courts are reluctant to provide absent clear evidence that supports the decision to reverse. And that discretion.
Mr. Hicks, I'm sorry to interrupt you, but when the 4 lieutenants who were seeking a change to the rule approached the commission, were they approaching the commission in a legislative fashion or in more of an adjudicatory fashion where maybe prohibition would have been the issue rather than, or how would you describe that particular proceeding and how the commission dealt with it?
So that proceeding, in our Civil Service Commission, there are various things that are presented every second Thursday. And some things under our Civil Service Rule 17 are provided for certain types of things: dismissals, reclassification studies, discipline discharge of suspension over 3 days. You get a quasi-judicial hearing. There also are provisions in our Civil Service Rules for what's known as an appearance, where people can come and air their grievances with the commission, and the commission can take action. However, there isn't the quasi-judicial nature of the hearing, and there's no court reporter, there's no cross-examination or trial-like formalities, and that's what this was. And they were able to say their piece. Various people spoke, and they were there for quite a while, but there was no quasi-judicial hearing from which a record, which would then be submitted to the Common Pleas Court, would be created. In this case, it's just an appearance by these members.
Thanks.
And Also, I would note that there was a discussion of that there was no motion for a TRO and that there was no time for these officers to stop this. Having been at the city for many years, we have TROs filed daily. I believe we had one yesterday, in fact, and they're often filed on just a few hours notice. So there was plenty of time for these officers if they wanted to file a TRO. And in fact, they were actually benefited because the people who had less than 1 year less than 2 years, had only a day to study for the exam. So apparently they were more prejudiced by the late notice than anyone. And I'm at my time.
Well, you've got 15 seconds. Oh, no,
Sorry.
you have. I'm sorry. I was reading it wrong, going in the wrong direction. Thank you, gentlemen. We will take the matter under advisement. You'll be notified of our decision.
Thank you.
We have Mr. Alexander. Oh, he's with you, Ms. Kern. I understand that. Yes, thank you. All right, our next case is 2020-1009 in the matter of the application of Suvon LLC DBA First Energy Advisors for certification as a competitive retail electric service power broker and aggregator in Ohio. For the appellant, Northeast Ohio Public Energy Council and Office of the Ohio Consumers Council, we will first hear from Mr. Stinson.
Thank you, Chief Justice O'Connor and Associate Justices. May it please the court, my name is Dane Stinson, and I represent Appellant Northeast Ohio Public Energy Council, or NOPAC. I'd like to reserve 4 minutes of appellant's time for the Office of the Ohio Consumers Council and an additional 3 minutes for rebuttal. Your Honors, NOPAC is a regional council of governments made up of 240 member communities. It's certified by the PUCO to provide competitive retail electric service to more than 500,000 customers in 20 Ohio counties. In the case before you, First Energy Advisors also applied to the PUCO to become a competitive retail electric service provider. In its application, First Energy Advisors proposed sharing senior management with its affiliates. Those affiliates are the monopoly First Energy Utilities. All three managers of First Energy Advisors were also employees of the utilities. Two of the managers, Charles Jones and Stephen Straw, were also directors of the utilities. The third manager, Dennis Schock, was the utilities president. Now, First Energy has since fired Charles Jones and Dennis Schock for the roles in the House Bill 6 bribery scandal that has rocked the State House and the PUCO in recent months. According to Appellee's brief, they were fired for failing to comply with First Energy's internal code of conduct. Now, Ohio has specific statutes and rules and its own code of conduct that governs a utility's relationship with a competitive affiliate. The code of conduct is in place to assure that a utility cannot provide its affiliate with a competitive advantage in the electric marketplace. This appeal addresses these statutes and rules and presents questions of law for the court to review de novo. Ohio's utility code of conduct prohibits a utility from sharing employees if the employees do not contemporaneously share information about the utility's operations with all other competitive providers. First Energy Advisors' sharing of senior management is a violation of the code of conduct. This is because First Energy Advisors' senior management necessarily would receive instantaneous information about the utility's operations well before other competitive providers, if the other competitive providers even receive the information at all. Now, for example, consider a new residential subdivision or a major corporation that contacts the utility to string distribution wires for new electric service. Because of its shared management, First Energy Advisors necessarily would know of this business opportunity before other competitive providers. That gives First Energy Advisors a competitive advantage to secure energy supply for the new project before its competitors.
Council, is there evidence that there was that kind of crossover of information and sharing of information?
Your Honor, we have been denied rights to discovery in this proceeding, so we don't have any specific facts on how that operates. We believe from the fact that the senior management team of the utility are the same, it's impossible to separate that information within the minds of those three managers. Now, to approve a certification application, the PUCO must determine whether First Energy Advisors management team is fit and capable of providing service. A management team cannot be fit and capable of providing service if it violates the Code of Conduct shared employees rules. The management team would be disqualified. However, the PUCO didn't bother to resolve this legitimate issue before allowing First Energy Advisors to operate. Worse, it shielded First Energy Advisors from discovery and hearing that would have developed a record on this legitimate and material issue. Your Honors, at this point in time, when First Energy's conduct involving House Bill 6 threatens the public trust in governmental institutions, the public needs the transparency that due process provides. NOPEC and the 7 other interveners who requested hearing in this case were denied due process at every turn.
Council,
No.
is there any, if you weren't, you say you were denied the access to the information you were seeking. Do you have any example of a project, a development, a new build, whatever, where there was some preferential treatment or, some competitive advantage from this provider or that this provider had? And, just not saying where that advantage came from, but is there anything specific?
I have to go back, Your Honor, to the fact that NOPEC and the other interveners in this case, the 7 other interveners, were denied discovery. We are unable to develop a complete record on that issue.
So the answer is no.
The answer is we don't have that information due to lack the ability not to have discovery.
What about the fact that PUCO had to act within 90 days and it was about 2 months before discovery requests were actually made?
I'm sorry, I didn't understand.
I said, what about the fact that the PUCO cites that it had to act within 90 days and that discovery requests weren't made? I'm assuming you intervened probably in January and that discovery requests weren't made for about 2 months.
Well, Your Honor, there's a process to submit discovery. We submitted discovery in February of 2020, shortly after we intervened. There was a process that requires consultation between the parties before a motion to compel is filed. NOPEC filed its motion to compel on March 20th. The PUCO is stating that a decision had to be rendered in this case by May 11th. Now, the PUCO had the opportunity to go ahead and order a hearing in this case, even shortly after the application was filed, and it had the opportunity to require that discovery be provided to the parties, in our case, in March before, with almost 2 months left. The other issue on that point, Your Honor, is that the PUCO never intended in this case to grant any motion to compel discovery. The staff report, the staff recommendation was filed in this case on April 7th. NOPEC responded to that staff report on April 14th. The commission staff placed this order on the commission's agenda on April 22. That would have given the commission approximately 19 days for discovery and hearing. So the commission never had any intent to grant any motion to compel. It sat on that motion until it approved the application. as we noted in our brief as well, that the rules for that 90-day process had been suspended by the commission due to the pandemic. In any event, Your Honors, I think as well that with the severe allegations in this case about non-compliance with the PUCO's rules, the commission could very well have denied the application, have required FirstEnergy Advisors to resubmit its application for discovery and hearing.
Thank you.
Counsel, you've got 7 minutes left, and I know that you have a time split here.
I'm just going to finish up real quickly so my OCC can get involved here. I just want to say a bit about the rules that provide discretion to hold a hearing in the case. The issue in this case is whether the PUCO abused the discretion, and NOPEC, and obviously first the commission did abuse its discretion in this case. The only reason it approved the application because it was concerned with the harm to FirstEnergy Advisors by the delay in its commencement of operations. The commission never considered the harm to the competitive market by permitting FirstEnergy Advisors to operate with a shared management. That's a classic textbook example of an abuse of discretion by being partial to FirstEnergy Advisors. At this point, I'll turn over my time to counsel for OCC.
Thank you. All right, Ms. O'Brien, are you going to save minutes for rebuttal?
No, Your Honor. Mr. Stinson will be doing the rebuttal.
Okay, you've got 7 minutes left, and he's reserved rebuttal time, so keep that in mind.
Okay. Chief Justice O'Connor and Associate Justices, may it please the court. My name is Angela O'Brien. I am counsel for the Office of the Ohio Consumers Council on behalf of Ohio Residential Utility Consumers. OCC supports Mr. Stinson's arguments for NOPEC. Today's appeals involve questions of law. The court should not defer to the PUCO. I will address how the PUCO's order violates RC 4903-082 regarding discovery rights and RC 4903.09 regarding complete records and cases. The issues in this case affect fair competition for energy services, and that affects consumers who the legislature intended should benefit from fair competition. FirstEnergy has led a charmed life at the PUCO regarding corporate separation issues involving a utility affiliate like FirstEnergy Advisors. Indeed, the legal problems in the case below are magnified by the fact that the PUCO did not even issue a decision on the original issues in FirstEnergy's general corporate separation case that has been pending since 2017. RC 4903.082 expressly states that, quote, all parties and interveners shall be granted ample rights of discovery. The Ohio Administrative Code further provides that, quote, any party to a commission proceeding may obtain discovery of any matter not privileged which is relevant to the subject matter of the proceeding. In an earlier OCC appeal where the court reversed the PUCO, the court recognized that the PUCO's rules should be, quote, liberally construed to allow for broad discovery of any unprivileged matter relevant to the subject matter of the pending proceeding.
Counsel, you have those discovery rules. You also have the expedited timeline for this process. So, you know, why didn't you proceed more quickly with discovery, knowing what the timeline was?
Yes, Your Honor. As Mr. Stinson said, NOPEC served discovery. They served a lot of discovery that would have been duplicative of OCC's. OCC followed up with discovery later on in the process. And FirstEnergy Advisors flatly refused to respond to any of NOPEC's discovery or any of OCC's discovery. There's a process required by the Commission's rules to proceed with motions to compel discovery that requires informal conversations with the counsel from whom you're seeking discovery or from the party you're seeking discovery. And we went through those procedures. So despite the law and the court precedent, the PUCO never ruled on OCC's and NOPEC's motions to compel FirstEnergy Advisors to answer our discovery. First, like I said, FirstEnergy Advisors objected to all our discovery. So the PUCO protected FirstEnergy Advisors from discovery instead of protecting consumers by enforcing our discovery rights. That brings us to RC 4903.09, which requires the PUCO to make a complete record. A complete record was not made, which we needed to build the record. We were next shocked to learn that the PUCO commissioners issued their order without a hearing. So the record in this case reflected the staff report and it reflected FirstEnergy Advisors application.
What was
With
the
that
nature- what was the
one-sided
na-
record, it seems
what
almost
was-
preordained that first, oh, I'm sorry.
What was the nature of the staff report? Was it extensive or was it sparse?
It was sparse, Your Honor. It was 2 paragraphs, and it basically reflected the fact that First Energy Advisors filled out the application to apply for a certificate. It did not address the corporate separation issues that NOPEC or OCC raised at all.
Thank you.
So with that one-sided record, it seems almost preordained that First Energy Advisors were going prevailed. The PUCO's process violated RC 4903.09. Especially in the wake of the House Bill 6 scandal, consumers deserve justice from the PUCO under the law. They didn't get justice in this case. The court should reverse the PUCO's order and remand in accordance with OCC's and NOPEC's arguments. Thank you.
What's the status of First Energy? What is the status of First Energy providers now?
First Energy Advisors.
I'm sorry, yes, advisors. Thank you.
Yes, Your Honor. They are currently certificated to provide competitive brokering and aggregation services, and they are currently providing service.
Under the same name?
Yes.
Did you raise on rehearing your argument that the commission erred when it found that you failed to expeditiously prosecute discovery?
Did we raise on rehearing?
Yeah.
We raised the discovery issue, Your Honor.
Okay, thank you.
Thank you, Your Honors.
Ms. Kern?
Thank you, Your Honors. May it please the court, I'm Kyle Kern, Assistant Attorney General. I represent the commission. I'd like to reserve 5 minutes of time for counsel for Subhan. Your Honors, this proceeding before the commission was a straightforward initial certification case under 4928.08. And under the law, the commission was to certify that the applicant had the managerial, technical, and financial capability to provide service and avoid default. That is what the
How
commission
could
did.
we review that determination when there's no findings or anything for us to review?
Your Honor, the Ohio Administrative Code is clear what an applicant to a certification case must include in their application.
So we should just go through their application and review it kind of de novo, since there's really nothing in the commission record?
The commission found, they adopted the staff report, which found that Subhan had.
The staff report is what, 3 paragraphs long?
Yes, Your Honor, but perhaps the more significant thing about the staff report is that it does not include any questions about Subhan's managerial, technical, and financial capability. There is no notation of any information that was missing or that the application was incomplete. There is no requirement in the statute that there even be a staff report, so the length is really insignificant here. It's the fact that the commission staff thoroughly reviewed the application and the application was complete.
Well, there is a requirement that the commission explain the reasons for its decision, right?
Yes, Your Honor. And with respect to this case,
and that reason was simply that no one's challenged anything. Is that pretty much the sum of
yes,
it?
appellants never materially challenged the core issue of this case, the statutory requirement.
Was it their burden?
No, Your Honor, and the burden never shifted to the appellant in this case. It always remained with Subhan. You can tell that from the commission's decision, where they said that Subhan had the managerial, technical, and financial capability to provide service.
Counsel, was the I guess for want of a better word, incestuous relationship known to the PUCO between the leadership at First Energy and the First Energy Advisors when it was being reviewed?
Your Honors, yes, the information about the management for Subhan was known. It was never not disclosed to the commission.
Well, all right, so it's disclosed, and there was no concern sua sponte that there was some maybe conflict at the very least here?
Thank you, Your Honor. This case is not about corporate separation issues. It's not about shared service employees or trade names. The commission has a separate docket for First Energy Corporation's corporate separation plan, where they have determined in their broad discretion and expertise that that is the best place to look at those issues. The certification statute for a competitive retail electric supplier is narrow. It's looking at managerial capability. Do they have that baseline managerial skill to be able to be a CREST provider in Ohio? It has nothing to do with shared service employees.
Well, all right, wait a minute. You got a board of advisors. First Energy Advisors has advisors. Am I right? And those advisors are First Energy corporate, top of the ladder people, right?
Correct,
So
Your Honor.
does not reflect, isn't that part of the analysis for competent management?
Not in this context, Your Honor. That is a corporate separation issue. And with respect to your specific question on shared service employees, the commission notes in its decision that it has allowed this on many occasions in the past. It does not go against commission precedent to allow shared service employees, nor is it on its face unlawful. There is no Ohio law that prohibits the use of shared service employees unless there is a code of conduct violation. The appropriate place to examine code of conduct violations would be in the context of a corporate separation case that actually arises under the corporate separation statute 4928.17. This is a certification case. If we look at this as an analogy we're all familiar with, we get a driver's license. That's the first step. And then we have to comply with the law. So this was the first step of the process. Of course, Suvan has to comply with the law. And the commission has mechanisms that they can.
Before they have to comply with the law, doesn't the commission have to find that they're capable of complying with the law?
And they are capable of complying with the law. And this is noted in the commission staff's report. Also, Suvan gave the commitment
anything
that they.
beyond just a conclusory statement saying that?
Well, Your Honor, in the Ohio Administrative Code, when there's a reference to capable complying with rules and orders, it's still in the context of managerial, technical, and financial capability, which are the statutory requirements in 4928.08.
Right,
case-
but I guess what I struggle with is I don't see anything in the commission's findings other than a blanket conclusory statement that they're capable of doing that. There's no explanation, there's no analysis, there's nothing there.
Your Honor, I would suggest that the commission has looked at hundreds of these types of initial certification cases, and they certainly know what information that they're looking for. The Ohio Administrative Code is pretty specific with that.
But how do we know what information they know that they're looking for if they don't tell us what they looked at, what they evaluated?
Well, the record is complete, and the Ohio Administrative Code states specifically what the commission must review in order to make a determination.
So do you think we should just really not review these at all then? Because there's obviously nothing for us to review here. So is this kind of the thing these just are unreviewable? Is that what you're saying?
I would suggest that the General Assembly, the intent was to get applicants to market, and that is evident in the fact that if the commission would have done nothing, on the 31st day, this application would have been approved. So the law tilts toward approving these applications. It's very specific.
As long as all the lines are filled in and the signatures are on it, that's pretty much all that's necessary for approval.
As long as the information that's required by the Ohio Administrative Code is provided, Your Honor, that is correct. The applicant will be certified. However,
so are you saying that this is clearly a ministerial process?
I'm saying the commission clearly reviewed this. They gave themselves the additional time.
Okay, all right, wait. You're saying that they know it when they see it. You're also saying that, the documents were filled out, every line filled in, signatures, etc. And that's all that's necessary. And an analysis is not necessary, and there's no report that would itemize or analyze their application here or their paperwork. So it sounds pretty ministerial to me.
I would agree in that they are looking for the specific information to make sure that it's there. Again, I would note that the commission staff did say they thoroughly reviewed the application and noted that nothing was missing. They didn't note any issues. In fact, they said that they recommended Suvan for certification and that they had the managerial, technical, and financial capability to provide service. I do want to stress that this is not a corporate separation
Ms. Kern,
case.
Ms. Kern, you've said that already, but how do you have discovery and a motion to compel in a ministerial process?
Your Honor, there's 2 points on these procedural arguments. First, that the statute does not mention hearing except with respect to renewals, renewals in Section D or suspension. So the commission had broad discretion. They had discretion here whether they would have a hearing at this stage. That would be highly atypical to have a hearing at an initial certification stage. Discovery isn't mentioned at all.
But they allowed intervention.
They allowed intervention. And I think the main point on these issues is that the commission did not need any information. They didn't need additional information. These arguments.
My point is, once the commission allowed intervention, it was turning this into at least a quasi-judicial proceeding, which was one of its options to do. And so why the rush?
Well, Your Honor, the rush is actually in the letter of the law. That is more an issue with the General Assembly.
Yes, the letter of the law was already lifted because of COVID. So there really wasn't that 90-day situation. Why the rush? Why no record?
Your Honor, there is a complete record, and it includes the application, the supplemental materials, and the commission staff's report recommending certification. The emergency order does contemplate that the commission would continue working on cases. So that didn't toll this specific case. Again, the timing issue that appellants have is an issue that they perhaps should look at the General Assembly for answers to. The commission was complying with the timeline. And here, I think the most important point, the commission had the information it needed to make the determination that Suvan should be certified. It did not need to have a hearing. It didn't need to go further. So it was, the commission did what it was supposed to under the law. I see that my time has concluded here. If I may.
I have one more question.
Sure.
So my familiarity with the commission's processes are that the application process often involves a lot of collaboration between the applicant and the commission staff, so that by the time the application is actually submitted, it's in the shape that the staff wants to see it. Would that be a reason why the staff had such a short 2 or 3 paragraph recommendation to the commission?
Your Honor, I don't think the length is of any significance here. And I did look at a few other dockets that were initial certification proceedings. And this staff report is not any different than those staff reports.
No, I'm asking about pre-application collaboration between the utility as the applicant and the commission staff. That happens regularly, correct?
It does in some cases. In this case, Your Honor, I think it's more regimented because the Ohio Administrative Code is specific of what's to be included. In fact, the commission actually has a form for these types of proceedings, and the applicant has control over how they answer the prompts in the form, but the commission actually has a form. So I don't know that there was, I'm not aware of collaboration between staff and the applicant in this case. And I think the purpose of the staff report was just to let the commission know that it had reviewed the application and there weren't any issues and that they recommended a certification. And in closing, Your Honors, this case is a certification case that deals with managerial, technical, and financial capability. It's not about corporate separation or market power or competitive issues, as appellants have argued. The commission's decision is lawful.
Thank you.
Good morning, Your Honors. Trevor Alexander, counsel for First Energy Advisors. I think the key point here is that the appellant's argument is completely dependent on the use of a trade name or the use of shared service employees being an automatic violation of Ohio law, making the management structure incapable of complying with the commission's orders. There's simply no support for that position. The commission has repeatedly ruled that the use of shared service employees is appropriate. The Ohio Administrative Code 4901-137 before, expressly anticipates the use of shared service employees. There's nothing inappropriate about that.
All right, do they anticipate the level of involvement of the caliber of First Energy employees with the First Energy advisors? Is that standard operating procedure where the folks at the top of the food chain are calling shots with the advisors?
Your Honor, the Administrative Code corporate separation rules prohibit actions, not people. And so there's certain actions which
I understand what you're saying. I'm asking whether this is standard operating procedure. You just said it's common to have this kind of a relationship. And I'm asking you, in other, businesses, such as what First Energy advisors are, providers, is it common to have, again, this level of expertise and status at the energy company to be their advisors?
Absolutely, Your Honor. For example, First Energy Solutions, who was formerly in contract with NOPEC, had a very similar structure, which NOPEC did not object to. We can also look at the cases cited by the Commission for companies like Dominion Retail, AEP Energy, Veteran Energy, Duke Energy. These were all cited by the Commission. This is incredibly common. And so the only way you get to these other arguments that are raised by appellants is if the court supersedes the Commission's decision to control its own docket and consider the allegations of inappropriate behavior in the corporate separation audit case. And let's talk about that because I think it's important. We're not leaving appellants without a mechanism to have these issues heard. Appellants have an audit case which is currently pending, which they are allowed to participate in, which they are allowed to conduct discovery. There's been a commission decision to take the Subban application into account and have judicial notice of that application. And so this is expressly teed up. These issues will be heard. They will have the day in court. But it's not an appropriate issue for this case. For this case,
But why is shared officership and so forth not relevant to managerial, financial, and technical ability to be certified?
Because I guess there's two parts. First, it's relevant to whether the individuals have the relevant expertise, because the applicant has the burden to show that they have the relevant expertise to serve as a competitive retail electric supplier. So it is relevant there. But it is also relevant to see if they are somehow automatically incapable of fulfilling that role because it would necessarily be a violation of the corporate separation rules. Here, there is no authority. The appellants have cited nothing saying that those actions are somehow an automatic violation. Instead, they have used non-record evidence and made ad hominem attacks against the company.
But would they need discovery to do that? I mean, seems like they might.
I don't think I would agree, Your Honor, solely because discovery would relate to the actions of those employees. What actions did they take? Did they take some action which violated Ohio law? The fact that they are employees of our shared service employees is stipulated. It's in the application itself.
Stipulated between whom?
I'm sorry, Your Honor?
Stipulated between whom?
Well, we would stipulate. It's clear on the face of the application that these are shared service employees.
So did you stipulate it with the PUCO, or did you stipulate it with NOPEC and OCC, or did you stipulate it with yourself?
It's listed in the application, Your Honor.
Thank you.
Thank you. Your time has expired, Mr. Alexander.
Thank you, Your Honor.
All right, Mr. Simpson, you are the rebuttal, and it looks like you have less than a minute. I'll give you 2 minutes. Mr.
Thank you,
Simpson,
Your Honor.
Mr. Simpson, my first question, Mr. Alexander has told us that all of your concerns can be more appropriately addressed in the audit case, which is ongoing and which you are a participant in, as well as your colleagues. Is that accurate?
That is completely false, Your Honor. First of all, remember that First Energy Advisors is not a party to the corporate separation case.
And
Also-
why is that? Why is that?
It was a docket initiated against the First Energy utility. The auditor in that case reviewed the relationship between First Energy Utilities and the former affiliate First Energy Services. First Energy Advisors has never been made a party to the case and hasn't moved to intervene. One thing I want to clarify is the question of law at issue in this case Now, the PUCO has to affirmatively find that First Energy Advisors management team is fit and capable of providing service and fit and capable of complying with the PUCO's rules. The legal question is, in making that determination, whether the PUCO must consider whether shared management is violating the code of conduct. If so, management is disqualified. If it's disqualified, it's not fit to provide service and the application should have been denied. Now, in this case, the PUCO acknowledged that First Energy Advisors' shared management structure remains an open issue. The PUCO granted First Energy Advisors' application, being fully aware that First Energy Advisors could be violating Ohio law currently. I think that's outrageous. The PUCO should have permitted discovery and held a hearing in this case before First Energy Advisors was allowed to operate.
Counsel, so let me ask this. Mr. Alexander said that this is standard operating procedure, AEP, all the energy companies are identifying their top-notch employees to be advisors to businesses such as First Energy Advisors. And it's done all the time, and it's obviously no problem with the PUCO. Is that accurate?
Your Honor, I don't have the information about the other utilities, executive management, and how they're shared. If we would have had discovery in this case in a hearing, maybe First Energy Advisors could have provided that information.
Well, what about NOPEC? Do you have advisors that are part of the utility structure?
No, we're completely separate from the utilities, Your Honor. That's the whole point, is that the corporation separation requirements are required to govern the relationship between the incumbent monopoly utility and its competitive provider. NOPEC
Right.
and hundreds of other companies are completely separate from the utility.
All right. Okay. Then I get the message loud and clear, is because First Energy was under this cloud, that should have, heightened the awareness of the PUCO in their review of this application. Is that accurate?
I think that's still true, Your Honor, that First Energy remains under a cloud. If you look at the appellee's brief, the appellee contains an order where the corporate separation docket has been expanded to consider those House Bill 6 violations of whether they protruded into the PUCO or rate-making issues.
But that's a whole different investigation and consideration, correct?
It's a part of the corporate separation investigation that the PUCO wants to put this issue to.
Counsel,
Okay.
the decision in this case by the PUCO, was it made before or after the allegations about House Bill 6 became public?
I believe it was made before the allegations were public, Your Honor.
Thank you.
Well, if it was before the allegations were public, what's to heighten their awareness?
Your Honor, I think at this point, the commission's awareness should be heightened because it's considering this issue in the corporate separation case.
Well, that's a different case.
It's the same case we're going to be involved in and what the PUCO
Okay,
wants us to
all right, I understand that, but we're looking at the application case here, and you're telling, and what I'm hearing is this is just a ministerial, fill in the blanks, sign on the dotted line, and we're going to rubber stamp your application as long as we feel that you've got the managerial, the capital, et cetera. And that's what is being portrayed here by the PUCO. And if they were not aware of the alleged abuses of the House Bill 6, how does this heighten their awareness or trigger a closer look or some kind of delving into the management issue because of the, again, cloud over First Energy?
Your Honor, first of all, I want to remark that the moment that NOPEC intervened in this proceeding, and NOPEC's intervention was not contested by First Energy Advisors, and the PUCO granted that intervention, At that point, it was a contested proceeding. And the PCO had to support its decision with facts under revised code 4903.09. It never did. It only made broad conclusory statements, as this was a ministerial proceeding, and it's not. It's a contested proceeding.
Okay. Thank you, Mr. Simpson.
Thank you, Your Honor.
You've used your time. Thank you. We will take the matter under advisement and you'll be notified of our decision. Thank you, counsel. Marshall, will you call a 10-minute recess, please?
The court will now adjourn for a 10-minute recess.
Newsderm. Our next case is 2020-1117, the State of Ohio versus Candale L. Harrison. For the appellant, Ms. McFall.
May it please the court, good morning. I'm Tina McFall, representing the defendant appellate Candale Harrison. I'd like to reserve 7 minutes for rebuttal. Candale Harrison raises two propositions of which are related both legally and factually. The third district declined to make a finding of the status of a document that purports to be an arrest warrant, which does not contain the signature of the issuing judge or any other court official. Prior to his arrest, you can reference
Does there need to be an arrest warrant at all in this case?
There does need to be an arrest warrant in this case.
Why? I mean,
because
he was arrested in a public place for probable cause.
The state failed to raise that argument in the trial court. In the trial court, from its opinion, clearly follows the minority, which the second district under statement.
But you can't be in the minority of the U.S. Supreme Court and the Ohio Supreme Court, right?
Well, in this issue, the Ohio Supreme Court in State v. Heston said that in Ohio, you have to have probable cause in exigent circumstances or a warrant if it's practicable to get one, and that was in 1972.
Yeah, but we were pretty clear that in Brown that you don't have to have a warrant, right? If it's
Brown was decided in 2007, and Brown actually did not reverse Heston and say that you don't have to have a warrant. And in Brown, it's factually distinguishable from Harrison because the police stopped Brown for an unauthorized license plate.
Okay, but if we follow the common law rule, which the U.S. Supreme Court has said there's a common law rule that you don't need an arrest warrant to arrest someone in a public place, what does it matter whether this warrant was invalid or not?
I don't think it's clear that we follow that rule in State v. Vinoy, which was in 2010.
Assume for a second that we did. Just assume for a second that we actually meant what we said in Brown, and that we do follow the rule, and we follow what the U.S. Supreme Court has said. Is that the end of the matter?
Well, in this particular case, there was a GPS warrant that was issued prior to the stop. So for practical purposes, Mr. Harrison was not just randomly in public when they stopped him. They were tracking him for more than that, issued on February 13th.
But he wasn't a public place when he was arrested, right? And you have to concede there was probable cause for the arrest, right?
If there's a probable cause for the arrest, if he were in a public place, and
I was a public place, right? He was on the road.
He was on the road. But in this particular case, the state never rose that issue at the trial level, and Mr. Harrison did not get an opportunity to respond. If he had been given an opportunity, he could have raised the issue about the GPS being warrant also being issued without probable cause. The vehicle in the case wasn't registered with Mr. Harrison. He had only been seen in the vehicle on February 2nd and prior to being issued. And if you look at page 70 and 71 of the transcript from September 10th, Detective Joseph said he had the GPS and was using it just so he could arrest Mr. Harrison when he got a warrant and he was ready to.
But in the intervening, counsel, in the intervening, wasn't there a traffic stop?
There was no traffic stop. And the trial court was clear on that. In the transcript, Officer Lehman only stopped Harrison's vehicle because he was told that there was a warrant for his arrest. And There was subsequently no warrant, and that's why the trial court found that there was no warrant in this case, and there was no other probable cause reason to stop the vehicle.
Counsel, the federal rules, criminal rule 4 requires a signature, and the Ohio criminal rule does not, correct?
Well, the Ohio rules are, if you're referring to the Ohio rules in criminal rule 4,
Yes.
the trial court,
Yes.
yeah, okay. The trial court found that to be issued, it had to be signed, that it was synonymous with being signed, that in this particular case, and in every case, that without a judge's signature, nothing can be said to be issued.
Well, I mean, if we wanted to say signed, we could be like the feds and say sign. Instead, we use the word issued, right? Those are two different words.
Those are two different words, but I would refer back to the trial court's decision that without a signature, then what would issued amount to?
But Ms. McFall, if we go back to February 2nd, 2018, when Detective Joseph used a confidential informant to make a controlled buy of cocaine from Harrison, wasn't that enough for probable cause, regardless of what transpired after that point? He already had probable cause, and presumably he let some time elapse to protect that confidential informant. But all this that happened with going to get this, getting the GPS, I'm just not sure that we even get to these issues, including good faith belief, because of that February 2nd confidential informant buy.
Well, that confidential informant buy, I would agree. If he had arrested him at that moment, he would have had probable cause to arrest.
But wouldn't that supply the same probable cause when he finally did arrest him?
I would again rely on State v. Benoit, State v. Heston, and State v. Jones. And so did Mr. Harrison in his pro se motion to suppress filing on April 4th. I believe it's documented.
Counsel, how does probable cause, if it's established, and you agree the controlled buy was probable cause, correct?
Correct.
How does that go stale? How does that not become, as legitimate when this was, when the warrant was sought?
Well, if the Fourth Amendment of the Ohio Constitution specifically says that a warrant is required to be free from unreasonable searches and seizures and should not be granted by anything less than based upon probable cause, but there is a warrant requirement. And under Xenia v.
Well, there's not always a warrant requirement. As Justice DeWine pointed out, if the individual's outside of their home or, in a public place, there's probable cause. The officer knows that there was a controlled buy and, and here a warrant was sought and issued. And there's nothing wrong with that probable cause. You would agree with that. The controlled buy is a probable cause.
The controlled buy is a probable cause.
Okay, that starts everything. That starts everything in motion. All right. And then Mr. Harrison is arrested in public, a public place.
He is arrested in a public place in a vehicle that's not registered to him. And
that doesn't, the vehicle's registration, there was a warrant to put the GPS on, right?
There was a warrant to put the GPS on.
So that's legit, to have that done. And I think that I don't see a problem with that. So what's your next argument that this was inappropriate?
Well, I would argue that a warrant was required because of the passage of time under the previous cases that I've stated and State v. Heston that was not explicitly overruled by Brown. And the second district Court of Appeals has been applying Heston, Van Noy.
Remind
And
me how much
Jones.
time, counsel, remind me how much time passed.
How much time from February 2nd until the warrant was issued?
Yeah.
Purportedly issued. That was Detective Joseph took 4 pages into the Belt Fountain Municipal Court on February 27th to get a warrant. And later, sometime that day, picked up 2 pages.
All right, so so 3 weeks later, he gets a warrant.
Yes.
And
And then
the council, the reason was to hopefully break the link between the controlled buys informant and the activity of the police.
I don't believe that he ever testified to that. He just said that he hadn't gotten to it when he got on February 13th to get the GPS warrant. And I don't think he ever testified in the hearing that he was trying to break the link for the informant.
Okay, is there some indicia of or time limit here that there's a progression here? The controlled buy, he gets then 10 days later a warrant for the GPS. It's not like there was inactivity between the controlled buy and on the 27th. It's a progression that law enforcement is working the case.
Well, the GPS warrant said that it was in effect while they were investigating the case or 45 days, whichever was earlier. And Detective Brent Joseph testified that he was following the GPS on the day that the stop was made for the specific purpose to effectuate the warrant, not investigating the case. And that is the transcript from September 10th at page 70 and 71.
But if the warrant is of no consequence, meaning it wasn't good and we don't even have to argue about the good faith exception, didn't he still have probable cause to make a public?
Without the GPS warrant, he would not have been able to make the public arrest. He wouldn't have known where Mr. Harrison was.
But there's no question about that warrant being okay, correct?
Well, that warrant says that it's in effect as long as there's an ongoing investigation of Mr. Harrison and or 45 days, whichever is earlier. And as I've
those 2 weeks then, the 13th to the 27th.
And as I've said, Detective Joseph testified in September 10th hearing on page 70 and 71 that he was using the GPS not to investigate Mr. Harrison, but to keep track of him so he knew where he was when he had the warrant to serve on him. So there was not an ongoing investigation, but the GPS was still on the vehicle at that time. So I would argue that the warrant had lapsed on the GPS once the investigation stopped, and he was continuing to follow that for the sole purpose.
Counsel, was this ever argued any place, what you're telling us now?
It wasn't argued at the trial level because the state failed to raise the issue of no warrant being needed. So if the state had raised the issue that no warrant was needed at the trial level, Mr. Harrison could have then had the opportunity to argue that the GPS warrant was infirm and that made a difference in this particular case. And even State v. Watson and Brown suggest that the Fourth Amendment needs to be analyzed with the facts of a particular case in mind.
All right, Counselor, you're pretty much out of time. All right, Mr. Stewart.
Thank you. Good morning, Your Honors. May it please the court. Eric Stewart for the state of Ohio. So the purpose of the exclusionary rule is to deter police misconduct. It's supposed to be a deterrence against deliberate, reckless, or grossly negligent conduct. And in this case, the defense has not pointed out any misconduct by the police. They point to the missing signature on the warrant, but that would be conduct by the court, not by law enforcement. And so,
Counsel, let me ask you about this a procedure that apparently is being done in this court system, that as soon as a judge signs a warrant, it is put on a public docket. And so that was the the problem, or I guess the motivation for only having the court initial the complaint, and with the, I guess, code or the assurance that probable cause was present, and then once the warrant's executed, the judge signs it, and then the clerk can put it on the public docket. Right?
correct. The impetus, the request from law enforcement was, please don't put it on the public docket.
Yeah, I understand that. I understand that.
Okay.
But, okay, can't the judge sign the warrant and not deliver it to the court, I mean, to the clerk to put on the public docket?
Absolutely, absolutely.
Well,
Because
then what's with this, the process? I got the impression that this is standard operating procedure.
well, it's not now. After the trial court issued a decision, the clerks down there were horrified, and so they made sure the judge signed it, and but they still keep it off the docket. So
okay, so that really wasn't a legitimate motivation for having this little signature on the complaint and withholding the signature on the warrant. It was just a misguided a protocol. I don't know who put it in place, whether the court obviously had to be part of it, and the clerk's office, but that wasn't at the insistence of the police department to not sign that document.
exactly. In fact, the law enforcement thought that they were understanding that it was being signed, but that they certainly did not request that the court not sign it. That was not. So in fact, Detective Joseph thought that he had a valid arrest warrant in his hand when they called him and said, the judge approved the warrant, come get it. They picked it up. He thought he had a good arrest warrant.
Counsel, what your colleague said is that this issue of that probable cause already existed, there was no need for a warrant, was not argued at the trial level. Is that correct?
I disagree. The state's argument has always been that there's probable cause. There was probable cause for the arrest, whether there was an arrest warrant or not. Now, did the state cite to Revised Code 2935.03 at the trial court? No, we did not. But our argument has always been a probable cause argument. This isn't like an issue of standing where the state needs, both sides actually need to develop the facts. There's burdens of proof. There's shifting burdens that have to be addressed. And in this case, there's just not that. The issue has always been, was there probable cause one way or the other? And that was established. In fact, the defense never really argued against the fact that there was probable cause. Their whole argument has been regarding the missing signature.
Well, why didn't you just say below that it doesn't matter if there's a warrant because this arrest is valid? You didn't say that in the trial court. You didn't say that in the Court of Appeals, as far as I can tell.
That's a good question. It probably just didn't dawn on me at the time to raise that argument, but it clearly is a valid argument that they didn't even need one. I think the defense raises the issue of how much time can pass before, can years go by before they affect a warrantless arrest based on probable cause in a public place. I think there still has to be some reasonableness involved in that. And the state cites to Hovater from the 5th District, where they found that 5 months in between the criminal activity and the arrest was reasonable. In this case, we're only looking about 4 weeks after the criminal activity. So I think that would be certainly reasonable to effect an arrest, warrantless arrest.
Counsel, was there anything about this procedure that was in place in this courthouse that confirmed that the judge actually reviewed the affidavit of probable cause before stamping it and sending it to the clerk's office? Was there any check in the procedure that confirmed that?
I'm not sure if I understand your question, but
Well, as I understand the procedure is the judge made it the policy that he wouldn't sign it until after the arrest, so the name didn't go into the system. But I'm just trying to figure out if there was any check in this procedure that confirmed that he actually read the affidavit. For instance, I mean, he's supposed to read the affidavit, and there might be instances where there was not probable cause established.
okay. Well, I can't tell you about procedure, but I can tell you what the clerk testified to. The clerk testified that that the Judge Beck did review the affidavit and did review the complaint and approved it, stamped it, probable cause, and initialed it. So
The judge applied the stamp and then sent it to the clerk.
yeah, it has the judge's initials on that stamp.
Okay. All right. Thanks.
So counsel, what you're relying on here is the good faith exception overarching this whole thing, no matter what happened, you know, whether the initials and the stamp are good or whether, you know, obviously the issuance of a warrant, does issuance require a signature? Put all that aside. The detective had a good faith belief that he had a valid warrant when he stopped and arrested the defendant here, whether it was in public or whether it was, you know, anyplace else. He thought he had a valid warrant, and that was based on good faith. And since the police officer didn't precipitate the confusion about the validity of the warrant within the court, that bolsters his good faith.
Yeah, that's exactly the state's argument. And the third district, they also kind of went the same way. They saw, well, we don't really want to get into whether a signature was required or wasn't required under Criminal Rule 4. Obviously, the officer in this case was acting in good faith. He believed he had a valid arrest warrant. Yeah, even
Should we get into that, counsel? Should we answer that question if we say good faith? You know, the irregularities of the court and the clerk are irrelevant here because the officer knew that there was probable cause. He had gotten a legitimate GPS warrant. And to effectuate the arrest, he had a document in his hand that he believed was a valid warrant.
Yes, I would say that because at this point, you know, the Bellefonte Municipal Court has already changed their procedure.
But good faith is based on an objective belief and not a subjective belief. And when you see on the second page of that warrant that it's not even dated or signed by a deputy clerk, when it says you are hereby commanded to arrest defendant, I mean, how could that objectively be good faith when it's blank and anybody could look at it and see that?
Well, the detective testified when he picked up the packet, because we're talking about a packet of papers here. The very first page is the complaint, and he saw the stamp, probable cause found, signed by the judge. At that point, he thought he was good. There was no evidence to the contrary that he had flipped further through the document. When he had presented that packet of papers to municipal court, it had an attached warrant. It did not have an attached summons to it. So it was reasonable for him to assume that the warrant had been issued because he saw the judge's initials, saw the probable cause finding. The clerk told him that the judge had issued a warrant. So I think he was perfectly reasonable. He certainly wasn't reckless or grossly negligent.
Well, and if we apply an objective standard, which means that the officer should know what the law is, wouldn't a reasonable police officer have known they didn't even need a warrant, so it didn't matter for this arrest?
Yeah, there's that too. Yes. And you know, finally, really, when you look at the signature requirement, is that really a constitutional violation? The Constitution requires probable cause, and I think everyone the trial court, the third district have found that there was probable cause for this arrest. If there is some defect in the warrant because of the missing signature, that would be a statutory or criminal rule violation. That's not a constitutional violation. And only constitutional violations require exclusion or suppression of the state's evidence. I have nothing further, so.
Okay, thank you. Thank you, Mr. Stewart. Ms. McFall, I think you've got a little over a minute left.
If the good faith, if this court is looking at whether or not a warrant was valid and issued, Detective Joseph said he took a 4-page document in to be signed. The complaint, the warrant, and 2 pages of affidavit. What he picked up was 2 pages, and those 2 pages were the warrant and the complaint. And if you only look at those 2 pages, which is all he had when he thought he had the warrant, then no person, no reasonable person could have found probable cause based on those 2 documents that he had in his hand. That probable cause stamp said there was a hearing held. Detective Joseph knew he didn't participate in a hearing. He no longer had the attached affidavit. There was nothing more than a conclusory statement that Mr. Harrison had trafficked in drugs, and that is it. So no reasonably objective officer could have thought they had a valid warrant when it wasn't signed. It had no command. There was no command whatsoever to arrest anyone on it. And the probable cause, just on what the judge reviewed, purportedly was lacking. It wasn't until March 6th that affidavit as Exhibit 1 showed back up, and there was no timestamp on there, no signature from the judge, no indication on either document at any point that the judge ever saw that affidavit. And the warrant was signed.
Counsel, is there a place for a judge to sign the officer's affidavit?
There was not a place for the judge, but there was no indication, and the warrant wasn't signed. So there's no way to tell what the judge relied upon in this particular case.
The warrant was filed or was signed subsequently, and there is the stamp, probable cause, I think probable cause, and the initials of the judge. What do we make of that?
Well, the judge didn't sign the warrant subsequently. A deputy clerk did.
Okay.
The judge didn't sign the warrant subsequently. There was no signature from a judge on the warrant at any time.
Was that necessary? I mean, you're saying because there was no signature on the warrant from the judge, that's fatal. That's a constitutional violation.
I'm saying that there's no way to make a determination whether or not the judge ever saw the affidavit that was purportedly attached. It wasn't attached when Detective Joseph picked it up. I don't know at what point or if it ever was attached within the meaning of a regular meaning, affixed, stapled. There's no indication that that was in fact true. So even though Carla Stevenson testified, the judge at the trial court level said he's free to evaluate the credibility of the testifying witness and make a factual determination. And the judge said that Carla Stevens gave testimony, but he relied on Defense Exhibit H. And it's clear from his opinion that there is no attached affidavit that would support the judge had ever seen it.
Okay, thank you.
Thank you.
Thank you, counsel. We will take the matter under advisement and you'll be notified of our decision.
Thank you.
All right, our last case this morning is 2020-1266, the state of Ohio versus Edward Maddox. For the appellant, Mr. Miley.
Chief Justice O'Connor, and may it please the court, Andy Miley for the appellant, Mr. Maddox. We reserve 5 minutes for rebuttal, please. The state of Ohio and its attorney general insist that the General Assembly may enact a sentencing scheme codified within the Ohio Penal Code and immunize that sentencing scheme from facial constitutional attack in any proceeding where the fundamental and constitutional right to counsel attaches. This is not the purpose of the ripeness doctrine. And in fact, in its merit brief below, the state never raised the ripeness doctrine. That doctrine is a judge-made rule of judicial restraint that promotes judicial economy by barring lawsuits about hypothetical or abstract concerns. But here,
I hear you on the ripeness issue. Was or was not an objection made at trial at the time of sentencing about the constitutionality?
No, but plain error is, no, it was not, Your Honor, but that's why in the Court of Appeals, we raised 2 assignments of error, which would be plain error, which is always preserved, and also ineffective assistance of counsel for not raising that issue. So as I was saying, the state here prosecuted Mr. Maddox. Mr. Maddox did not bring this case. This case was brought to him. And he contends on the merits that the statutes that he's already been sentenced under in this case are invalid and void ab initio. Therefore, his purely legal challenge to the statutes at issue have nothing to do with hypothetical, abstract, or future conduct. Plus, affirming here would drain, not conserve, judicial resources. This is because a felony defendant always retains an automatic right of appeal under Revised Code 2953-02, and in some cases under 08. But according to the panel below, the person may not appeal the constitutionality of the very sentencing scheme they were sentenced under. The panel said that this has to be separately brought in piecemeal litigation, civil habeas corpus litigation, where no right to counsel attaches. And because no right to counsel attaches, most habeas litigation is brought by pro se inmates, and therefore the courts don't benefit from professional advocacy. Beyond this, the certified question actually skips a more fundamental point. That is, when is a facial challenge to the sentencing scheme ripe in the first instance? The answer is at the common pleas court, the trial court, the sentencing level. And that's because if a sentencing scheme is invalid, as we contend here, then the common pleas court judge should not impose sentence under that scheme in the first place. And I want to, again, be very clear that Maddox merits theory, I know the merits aren't at issue on the certified conflict appeal, but his merits theory does not depend on future happenings. We agree that the government is correct that Revised Code 2967271 is the statute that purports to give the prison department the power to hold an inmate for an additional period of incarceration. But Maddox's theory is that newly enacted 292914A2A, which is the minimum sentencing statute, and 2929144B1, which is the maximum sentencing statute, which they were both enacted at the same time as 2967271. Those 2 statutes, the minimum statute and the maximum statute, are the first 2 steps in an overall unconstitutional plan. Therefore, Maddox, in his appeal, was resisting the exaction of the indefinite sentence as the first step in an unauthorized plan. This is analogous to the third supplemental authority that we cited, Beaver Excavating versus Testa, the United States v. Butler, where this court in Beaver and the United States Supreme Court in Butler said when a series of connected statutes are passed at the same time, their validity is not determined in isolation. So the minimum sentence statute and the maximum sentence statute only serve the purpose of enabling the prison department's power, which we think is invalid. So if we're correct about that, so we get to peek through to the validity of 271 to determine the issue at bar, which is the invalidity of 14A2A and 144B1. Now, that doesn't mean...
Counsel, the conflict cases that are cited don't they that we cited assume that there's ripeness, that the case is ripe for hearing, but never really reach the issue of ripeness? Isn't that correct?
They don't mention ripeness, and I think that is correct, but I think that is appropriate because it's so obviously ripe, there was no need to mention it. So there's a conflict because in certain appellate districts, appellate courts are not opining upon the constitutionality of these interconnected statutes. And in other appellate districts, they are opining upon it. And recently in our 4th and 5th supplemental authority, the 8th District Court of Appeals has found Tokes invalid.
So can we parse this between facial and as applied? Because I think you're arguing primarily facial, but then some of the courts that have said it's not ripe for as applied are saying that you have to wait until it's actually applied to extend the incarcerated person's sentence.
Yes, I think a facial attack definitely is ripe at this point in time. And that your question gets to the 2 factors. We don't think I want to answer this in 2 ways, Justice Bruner. We don't think the ripeness doctrine applies at all because we are attacking the imposition of the indefinite term itself. We're saying that this scheme is facially invalid, and accordingly, the repeal of the definite sentencing scheme is itself invalid, and we should have been sentenced under the definite sentencing scheme regime that was in place prior to March of 2019. But I think, Justice Bruner, there's 2 factors. Even if the ripeness doctrine might otherwise apply, which we deny, the courts look at hardship and fitness. So fitness goes to what needs to be developed. And does there need to be a developed record for a court to determine this legal challenge? And for a facial challenge, there's nothing that needs to be developed. It's just a pure legal challenge. And as applied situation maybe it won't be fit because we'll have to see what happens. But there's also the hardship situation, which here there's plain hardship merely because of the right to counsel issue. The state should not be able, if this court affirms, you're essentially saying that the legislature may strip the constitutional right to counsel by legislative fiat by enacting an indefinite sentencing scheme. And
counsel, if your client is incarcerated, which he is, and 4 years pass and he's released from prison.
Yes.
Then he's happy and you're happy.
But that's not really the point of our challenge here. The point is that there was no power to impose an indefinite term in the first place. So he cannot be subject to the coercive effects of the Tokes law because if in fact that law is invalid. And that's the only thing we're asking the court to do in this case is give us a chance to be heard on our facial constitutional attack.
So if he's subject to judicial release or he's subject to post-release control, there still is a concern because if he messes up, he could go back into prison and then he could still be subject to the Tokes law, correct?
That is correct. He would always be, once the sentence is imposed, he would always be subject to the terms of that law. And really, we think that the rightness of the Tokes law comes to bear the moment someone is indicted, because that person has a right to know what is the sentencing scheme attached to my case valid or not. So that goes to, plea bargaining process. Can the state hold this sword of Damocles over everyone's head in the intervening years until 5 years, 4 years from now, we get a habeas corpus decision? That goes to hardship. Is it a knowingly voluntary plea if we think, hey, my lawyer says that this law is unconstitutional, but the trial court judge and the appellate court is saying that it's not ripe for appeal? So there's all these factors that go into it. Next, I want to point out that in the supplemental authority that we cited, the state in trial courts in Ohio where the state has lost at the trial court level and the trial court judge did exactly what we're saying. Hey, I'm about to sentence this defendant and I need to decide, do I sentence under the Tokes law or not? Because the Tokes law may be invalid. And in those cases where the judge invalidated the Tokes law and therefore sentenced under the prior scheme, which is the definite sentencing scheme, what does the state of Ohio do in those cases? They appeal on the merits and say, oh, the finding of unconstitutionality was wrong. So the state has really been inconsistent on how they've approached this issue. They're basically saying, yes.
Counsel, what you're asking us to do is just say this is ripe for review and remand it to the 6th district. Am I correct?
Chief Justice, that's all we're asking in this case. I want to make one more point before I reserve the balance of my time. If this court, that's what we think should be done. However, if this court affirms, then what we would ask you to do is vacate all of the decisions upholding the Tokes Law, because then those would have been issued in violation of the ripeness doctrine. The state can't have it both ways. Unless there's any more questions, I reserve the balance of my time.
Okay. All right. And for the state, we're going to start with Ms. Brayman.
Thank you. Good morning, Chief Justice, and may it please the court. My name is Allie Brayman, and I'm here today on behalf of Julia Bates, the prosecutor for Lucas County. I'll be sharing the last 5 minutes of my time today with my colleague from the Attorney General's office, Ms. Bry. The Reagan-Tokes Act creates a presumption that an offender will be released after serving the minimum part of his sentence, but it also allows ODRC to rebut that presumption and keep the offender in prison up to the stated maximum term. The only question before the court today is whether a claim that those provisions of the act are unconstitutional is ripe for review on direct appeal from sentencing. The answer is no. Ripeness is all about timing. And this court has said that a claim is not ripe for review if it rests on contingent events that might never happen.
So counsel, if you fast forward and 4 years pass and somehow the DRC, which is the decision maker here, right? Not the court, you know, it's a executive branch decision, right?
Correct.
Decides for some reason they're going to keep him another year. Correct. Then you're saying he has to institute a habeas action. Correct?
Correct. Yes, Your Honor.
All right. And what I've always found problematic with habeas action is illegitimate that he is being held. All right. Then, you know, he is detained, incarcerated illegitimately. What is the recourse then for this defendant if he's spending a year in prison while the legal system addresses his complaint and they find that that he shouldn't be there? It invalidates the decision of the DRC, finds it to be unconstitutional. What happens to any defendant under those circumstances? Is it just tough luck? You had to go through it. That's all there is to it.
Well, Your Honor, first, I believe there is a process for habeas where it can be filed directly to this court and they can ask for the review to be expedited. So that's one potential way that the process could be sped up. But if it gets to the point of where this court says that it is unconstitutional, I believe there are procedures to repay that defendant. I believe there are ways that they can receive money for the days that they are spent incarcerated under the invalid sentence. But my argument
don't they have to file a lawsuit for that?
I believe so, but I think that is a potential recourse that they could do at
Sure,
that point.
with no counsel provided, just like with habeas, right?
But I think that the court has every discretion to appoint counsel in that position. And I believe that courts would be likely to appoint counsel in that position. And so they would have counsel and then they will be represented during that suit.
That's a statutory remedy. I don't think there's anything in that statute that permits the appointment of counsel. Do you?
I don't have the statute in front of me and I'm not 100% familiar with that statute, but I think the argument of the likelihood of success down the line is a future concern. The concern right now is whether this issue is ripe for review right now.
So if a judge puts someone on post-release control or says or instructs them that they may be on post-release control for 3 years, can a defendant can challenge that before he or she's actually been placed on post-release control, right?
I think the defendant can challenge the court's compliance with the post-release control statute, whether the court notifies that it's mandatory or discretionary.
And so why is that different? Why? I mean, that person, if it's a discretionary post-release control, the person may never be on post-release control. So why does that person get to challenge the judge's advisement at sentencing, but a person under Reagan-Tokes has to wait until they've actually been given the extra time?
Well, Your Honor, the difference is that in the post-release control example that you just gave, the person is challenging the advisement. Under Reagan-Tokes, there are certain advisements that have to be given at the sentencing hearing, but that has nothing to do with the actual execution of what could happen down the line.
Wait a minute, the advisement, you're saying, defendant, you're liable for post-release control, and here's what that's all about. Well, what if they're not liable for post-release control? What happens if the judge made a mistake and they're not, subject to post-release control?
And that's an issue that can be brought on direct appeal because that is something that is imposed at the sentencing hearing. Post-release control is imposed at that time.
It's imposed, but it's not triggered. It's just like this extra time at the discretion of the DRC is imposed, but it's not triggered.
Exactly. And the constitutional violations that Mr. Maddox is claiming don't happen. They're not triggered until his minimum sentence has been served.
Well, neither is post-release control. That's the point.
But exactly. And there are cases out there, and I believe the State v. McCann case from the 8th District was the one that the 6th District relied on in this case, where the defendant tried to argue that the post-release control statute violated his constitutional right to a jury trial because it provides the parole authority with the authority to send him back to prison if he violates post-release control. And that's exactly what the core concerns here are, is that ODRC has the authority to hold this hearing and determine whether the presumption of release has been rebutted. But he's not subject to that statute right now. It hasn't taken effect. It won't take effect until he serves his minimum term.
But he is subject to the statute.
Correct, but the application of the statute hasn't taken effect. He could be released early. He could be perfect inmate while he's incarcerated, and the conditions necessary to rebut the presumption might never happen. And in that case, ODRC won't even hold the hearing. He'll serve his minimum term and he'll be out. There's no harm. And there has to be some harm for this court or any court to review the issue.
But if you compare this to post-release control, there's some that is mandatory and some that is really subject to ODRC. I mean, doesn't this just really go back to what scheme you're sentenced under? Because I mean, if there's a requirement of the advisement, then it becomes part of the sentencing scheme. So why treat post-release control one way and the Reagan-Tokes Act another way?
I don't necessarily think that they are treated differently because these arguments aren't challenging an indefinite sentence. The argument is not that an indefinite sentence itself is unconstitutional. The argument is that giving ODRC this authority to hold this hearing, that's what's unconstitutional. And in the post-release control context, the argument is that giving the parole board the authority to do this down the line is what's unconstitutional. But that hasn't happened yet, and it might never even happen.
But you're saying that it's not ripe in the Reagan-Tokes situation, but that challenge, you're saying that there is an argument that DRC should not have the authority for this, but that's not right to challenge. Yet you can say under the post-release control challenge, if the challenge is that the parole board is in error to impose this, that is ripe for challenge.
But courts have said that it's not ripe. Even before this court decided the Bray v. Russell case and Woods v. Tell, which dealt with the former bad time statute and post-release control, court said until you are subject to application of that statute, it's not, your constitutional claims are not yet ripe for review. And right now, he hasn't served his minimum term. He might never completely serve his minimum term or be subject to this hearing by ODRC.
But
So
that's an as-applied challenge. What about a facial challenge?
I think there is an argument that this is a facial challenge, but again, it's the two or three specific divisions of Revised Code 2967.271 that are the core concerns here. And those just don't apply. ODRC can't even take any action until the minimum term has been served. And there are so many things that could happen that hearing won't ever take place, that it's just too early to address these concerns now.
But isn't if you look at the statutory scheme on post-release control, it's required based on certain types of crimes. Even the permissive is required on certain types of crimes. But in this case, so it's related to the actual crime. In this case, the extended sentence is related to something that's not adjudged by a court, that's not under the criminal code based on a particular crime. It's based upon the judgment of officials in the prison system. Am I correct?
Correct, it is. And that goes to the merits of these constitutional arguments, which is, again, not why we're here. We're here to determine whether those claims are ripe for review.
But doesn't that go to the facial validity of the statute? And wouldn't that be ripe at any time?
I don't believe so, because the statute just hasn't taken effect yet. I understand it is a facial challenge, which can be considered, but if we don't know if he'll ever get to this point, it's just too early to even address the issue. And
why doesn't he have standing? That's what you're arguing. Why does he not have standing?
Because the statute doesn't apply until he served his minimum term.
But he's advised of it at sentencing, right? So doesn't it apply?
He's advised that it will apply to him at some point, but it hasn't taken it doesn't apply yet.
But then it can't be imposed on him if it's not advised at the time of the sentence. Am I correct? Just like post-release control?
Exactly. There are certain things that it has to be imposed at the sentencing hearing. And if he serves the minimum term, and if ODRC decides to keep him past that term, then he can raise these constitutional arguments. I see I'm running into my colleague's time, so if there are no further questions, I would just ask that the decision below be affirmed. Thank you.
Thank you. Ms. Bry, colleagues saved you about 3 minutes. If you unmute yourself, we'll hear you.
I apologize for that. Thank you. Chief Justice and Justices, may it please the court. I want to address a couple of the points that have come up here. One is about the question about post-release control. Of course, that's been built into felony sentencing for such a time that for a serious felony, it's part of the sentence. And we need to remember too, that because this court in Woods v. Taub decided the constitutional challenge to the post-release control 21 years ago, which was in the context of a habeas case, the appeals that we get today in post-release control tend to be more about the advisement. So it's really actually the Woods case and Bray Russell in terms of the mode of action is more similar, because those were extraordinary writ cases where the court did address a constitutional claim that is more similar to this one. The ripeness pertains to the court's jurisdiction and ensures that the court will not issue advisory opinions or answer hypothetical questions. And that's important in any case to preserve that and answer that question correctly, which is why we say that this is not a ripe case, because although the defendant says that he's challenging the whole sentence, what he's really complaining about is DRC's execution of the sentence, potentially at some point into the sentence, so that he might get more than the presumed minimum term. The presumed minimum term is, that's that gives him an expectation in a way that's a little different than the old indefinite sentencing scheme that we had before 1996, that nobody thought that DRC's or the parole board's involvement in it presented a constitutional problem to decide when somebody should be released. Here it's a similar scheme, except that the presumption is changed. So that
right, isn't ripeness a judicial creation? And if it is it based in any particular section of the Constitution?
Your Honor, it's a doctrine that the courts have enunciated, but it is based on jurisdiction because it's important for courts to avoid issuing advisory opinions. That is a jurisdictional concern. And so that gets at the court's jurisdiction to address actual cases that are coming before it and not abstract questions, such as some of the cases we've cited at page 8 of our brief. State against Loving was one of them. Another example where this court declined to reach a constitutional issue was a State v. DH, a juvenile case. So there are other times when the court has looked at these issues and decided that notwithstanding somebody bringing it in an appeal, that was not the correct time.
But is there anything in the Ohio Constitution, because I mean, our jurisdiction, as well as the jurisdiction of the lower courts of the state, are established by the Constitution, but ours is a bit different from the appellate and the common pleas courts, whose jurisdiction is then extended as established by the legislature. For the Ohio Supreme Court, our jurisdiction is established squarely in the Ohio Constitution. Is there something that would prevent us from looking at that issue?
Your Honor, it's that the ripeness doctrine does have the jurisdictional component, as we've discussed, in terms of addressing actual cases, and the courts. And I apologize, I don't have the court's jurisdictional constitutional provision in front of me, but there is still that tie to actual cases that makes the ripeness doctrine pertinent here. And in conclusion, we think that the case is the challenge that this defendant is making to his sentence, which has to do with, will he be allowed to be released at some point after his minimum term, that is not yet right. We understand that if the court disagrees with that, as we said in our brief, we would simply ask that the court then remand this case to the 6th District and take a case where the merits issues have been preserved so that they can be fully briefed. But again, we believe this case is not yet ripe. This claim is not yet ripe for decision.
All right, thank you.
Thank you very much.
All right, counsel, you have reserved about 4.5 minutes, it looks. Counsel.
Sorry about that. This case has stayed merits cases pending outcome of this case. So we too agree that this case should be remanded to the 6th District for determination on the merits. And if that happens, what I would do is I would just petition the 6th District to stay the case pending this court's decision in the state merits cases. But the state and the Attorney General really haven't answered the question of, when has a doctrine of judicial restraint ever been invoked to create piecemeal constitutional litigation where the right to counsel would not apply? And there's no answer that counsel might be appointed. The problem is that the right just simply does not apply. We searched, we could not find any case like this. And also I keep hearing the state and the Assistant Attorney General argue that we're not challenging the indefinite sentence. Yes, we are challenging the indefinite sentence. We are saying that the minimum penalty statute and the maximum penalty statute are themselves invalid. And it was error for the trial court to impose sentence under those statutes. That's not a hypothetical or advisory or abstract issue. In a common pleas court, when a defendant is about to be sentenced and the defense counsel says, Judge, we believe that imposing sentence under the indefinite sentencing scheme is unconstitutional, and therefore we want you to sentence under the definite sentencing scheme. And the prosecutor says, no, we believe it is constitutional. for thus and such reason. That is a hot contest, hot controversy. That gives standing and that gives rightness. I want to just, I'm not saying the general, I want to use a hypothetical to illustrate something about what the state is arguing. The state wants this court to adapt a bright line test that anytime that there's an indefinite sentencing scheme, that the defendant can't do anything about it, can't have a lawyer. They have to file a separate civil lawsuit, and they can only do that after they're already in prison. So let's just change the scheme a little bit. Let's say that the definite sentencing scheme exists, the same Tokes law is passed, but there's a provision at the end that says the indefinite sentencing scheme only applies to minority defendants. And there's two co-defendants, a white man and an African-American man. And they both go to sentencing in the same case. And the judge gives the first defendant 4 years, and then the African-American defendant is up, and the judge says, well, I give you 4 to 6 years. And that man says, well, wait a minute, this is unconstitutional. No judge, the Ohio Attorney General and the Lucas County Prosecutor's Office wouldn't argue that, oh, that person has to wait and see whether the prison department will hold them over beyond 4 years or not before they can challenge this. Obviously, that would be challengeable at the trial court level. And so I'm not saying the General Assembly would pass a law like that, but the very fact that the states...
But wouldn't the difference is what would be challengeable there is the difference in how the opponents were treated based on race?
That would be a facial attack too. It'd just be, it wouldn't be a different in kind. It's still a facial constitutional attack. It's just a difference in degree. And we're saying Maddox is saying my constitutional rights were violated, just like the man in my hypothetical. In fact, what we're saying is everyone's constitutional rights is being violated by the statutory scheme. So it's clearly a ripe issue. And to say, and back to Chief Justice O'Connor, asked the prosecutor, well, what is the remedy? What if this is ultimately found to be invalid? And the state says, well, he can file a lawsuit for some money. You cannot quantify a man's or a woman's freedom in that way. That goes directly to the hardship issue that we were talking about. Even if the rightness doctrine might otherwise apply here, courts will not employ the doctrine when it works hardship, particularly when the issue is otherwise fit for judicial review. Here it's fit because whether this statutory scheme as a whole, we're not saying view in isolation, as a whole is invalid, needs no further developed record 4 years from now. We ask you to reverse and remand. Thank you for your time.
Thank you very much, counsel. We will take the matter under advisement. You're going to be notified of our decision. Marshall, will you please adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.